very warm welcome to you, ma'am. Inviting Mr. G.V. Ashok, partner, Factum Law. Very warm welcome. Inviting Mr. Keyur Gandhi, head regulatory, Dhruva Space. Warm welcome to you, sir. Inviting Mr. Rahul Goel, partner, Anant Law, to kindly grace the stage. Warm welcome. Inviting Mr. Arjun Sinha, partner, AP and Partners. Very warm welcome. Inviting Mr. Hardik Gandhi, partner, Deloitte, Haskins and Cells. A warm welcome to you. So ladies and gentlemen, the topic for this session is navigating the laws for space business in India. The overall regulatory framework, both domestic and international, is what enables businesses to thrive. The sessions bring forth the critical aspects for space businesses for large organizations and startups to be aware of while making business plans, running and businesses, and new models for businesses. So ladies and gentlemen, the time duration is approximately 1 hour, 15 minutes. And with those words, I hand over to our keynote speakers and our distinguished moderator, Mr. Abhishek Malhotra. Over to you.
Thank you. We're going to be planning this session more as an interactive one with a conversational mode with all the panelists, just to discuss the various aspects of laws and navigating those laws for the furtherance of the ecosystem for space business. So I'd like to begin by introducing my panelists. Dr. Ranjana Kaul, who's a partner at Dhruva & Associates. Dr. Kaul has been practicing over the last over 30 years. I was not given that input, so that's why I thought possibly. Her practice includes general legal advisory services to corporates across sectors, including IP, contracts, and FDI. Her area of expertise relates to international air and space law treaty regimes. She advises on applicable international space treaty frameworks at the intersection of applicable national policies and laws in India, and on aspects related to drafting national space policy and space activities law. Mr. Ashok GV, who's a partner at Factum Law, he's an attorney specializing in commercial disputes, representing clients from aerospace, healthcare, manufacturing, and technology industries in the IP, taxation, and company disputes areas. Mr. Keyur Gandhi is the head of regulatory and legal affairs at Dhruva Space. He works extensively on the telecommunications and space regulations, often engaging in policy and commercializing processes for Dhruva Space. He has also been working actively on the front of space law and policy with associations such as SIA, where he's a part of the Space Law Committee. Mr. Arjun Sinha, who's a partner at AP and Partners, he advises a diverse set of clients on corporate, M&A, and regulatory issues in the telecom and technology space. He has, in the past, advised leading domestic and global players in the space, telecoms, new mobility, social media, and e-commerce industries. Mr. Rahul Goel, who's a partner at Anant Law, has over 21 years of experience in advising, assisting, and representing clients on a wide variety of legal, regulatory, and policy issues. Thomson Reuters Asia Legal Business has recently ranked Rahul among the top 15 TMT lawyers in Asia. He has consistently been ranked among the leading lawyers in TMT and competition by Legal 500, Chambers, and Partners in Asia Law and Practice. Mr. Hardik Gandhi, who is a partner at Deloitte, Haskins and Cells, he's with the indirect tax practice. He has experience of over 13 years in a wide range of indirect tax matters with a particular focus on the TMT sector and the consumer industry. So with that introduction, ladies and gentlemen, where I think you would have possibly garnered that this panel has a wide variety of experience across different aspects of businesses, not only in the space sector, also in the TMT sectors overall. And we hope that this engaging session will throw some further light on the interesting and possibly ambiguous area of what we need as a law, or whether we already have that, which can help in navigating the space businesses in the country. So as I said, we're going to have this in a conversational sort of mode, and I'll just hop over across to my seat and carry on the proceedings from there. Part of the reason why I took those extra 10 seconds to walk up to my seat is I was hoping that we'll have more people joining us. But I think as the session progresses, we hope to be the magnet to attract those people inside. Well, without further ado, what I'd like to start off with is a conversation with Ms. Kaul, who I would like her to throw some light on this particular topic with her extensive experience in this area, because Dr. Kaul has seen what can perhaps be, it was oft repeated through the course of this conference over the last 2 days, that the space industry, and specifically the commercial space industry, is at a juncture where we have partially already taken off, and there is a need for creation of an ecosystem, both from a technology standpoint, from a business facilitative standpoint, and certainly from a policy and regulatory standpoint, to take this sector to realize its true potential. So I'd like to ask you, Dr. Kaul, as to what you think, given your experience, has been the roadmap till now, with a little bit of a background on that, and what you perceive to be the most important, perhaps, 2 aspects that are needed to really set the law in motion as we know it, to help navigate and foster the space ecosystem in India.
Thank you, Abhishek. So, how do I perceive it up until now? Which up until now, let's take the announcement in the summer of 2020 that Prime Minister made, and that announcement has 3 principal elements. One is Atmanirbhar, which is self-reliance. The other is leveraging India's advanced capabilities, that is space capabilities. And the third is the participation of the private sector in all aspects of space activities. So when you deconstruct all aspects, it obviously means the ground segment, because without building satellites and developing, doing R&D in science and then developing products, that is technology, to be deployed in outer space and to be able to launch, you're not getting into space. And the second, which we call the ground segment, the second is the space segment. The launch vehicles that will cross the threshold of the 100 kilometers, internationally recognized, though there's no written definition of where airspace ends and outer space begins. So entry into outer space to deliver this payload, the satellite, which is now tasked, because of the technology platform, enabled to do whichever function that it is tasked for. So when I look at this and I see the trajectory over the last 2 years now, 2 years and plus, this is what I see. Yes, we have had some draft space policies or separate space-enabled communication, space-enabled whatever. None of them have really hit the nail on the head in the context that there has been an absence of clarity, there has been more confusion. We do not know what is the aim of the exercise, what is the precise objective that the government of India envisages for India to be, let's say 25 years down the line, 100 years of India's independence, we're at 75 today, or 30 years, and say that at so and so time, this is what our country would have achieved in context to space. That has not happened as yet. And I've been wondering why, because in the absence of precision and clarity, everybody is running around doing panels like these saying, ki, karna kya hai, hoga kaise? What is it that we should and what is it that we should not? So above and beyond these gaps, here's what has been happening. Let me tell you, deconstruct the proposition in 2 bits. The first is private space industry, which is our legacy space industry. They form part of the ecosystem, which is the procurement vendors through which the ISRO has been generally getting all its hardware, software, etc., and undertaking our national space program. Those mature industries, some of them are legacy over 100 years old, are in capacity today and wish to undertake end-to-end space activities to be able to launch themselves. All of that setup is being governed under the normative laws of India, which is to say the law of contract, special conditions of contract, general conditions of contract, sectoral regulation, Ministry of Finance regulation, all of those things. But we don't need to reinvent the wheel here by enacting any law because they exist already here on ground. What is happening with that vertical is that today we have a situation where we are almost certain that in the near foreseeable future, you will have one of our private sectors actually launching a PSLV. And so forth. So those adjuncts. On the other side, what has happened in context to space-based communications, in this case communications, it could be remote sensing, could be anything else, but communication is the advent of, well, triggered by the ITU, the World Radio Regulation, the final outcomes, which were announced December 2019 in context to 5G, which has enabled this incredible kind of trajectory that we see in low Earth orbit of enormous, humongous satellite constellations being launched to provide broadband services. If any of you have been here in the last session, which is the defense, we had one of the speakers who was talking about balloons, high altitude. Because 5G, those final outcomes have said that 5G, wireless, it is a wireless communication revolution that is happening, will be capable of being deployed for high altitude platforms. So that includes drones, it includes balloons, it includes aerospace vehicles. And most panels are very excited about space tourism. So how do you do it? You need an aerospace vehicle to go through space, air, space, and then outer space. That is how it will happen. So that is the other part. And because India does not have an experience of private sector operating in outer space, we don't have a space policy in the way that the West understands it. That does not mean that the Department of Space is not conducting its affairs in terms of a specifically mandated framework and mandated under the Constitution of India. That is what it does. Now, because we want to accelerate the rollout of 5G, and we have not built that capacity ourselves to be able to launch those constellations, what we have done is that we have enabled a company which is incorporated in the UK, even though it has an umbilical connection with India, and I'm talking of OneWeb, but it is nonetheless not an Indian company. But that and others such as that, that you have Reliance is in joint venture with SES of Luxembourg. You have Nelco, which is in joint venture with Telstra of Canada. These are other Indian companies that are going to come with this service. And already in 2018, downstream telecommunications, and you would know that, the National Digital Communication Policy had already started preparing the ground, and then Digital India, all that. That stream has been connected, the dots are connected. And you now have a situation where OneWeb has been given the license, and soon enough, all of us will be on broadband. That is happening. I see it as a natural progression because, in a sense, it is low-hanging fruit. The other important thing that has happened, and which one of the earlier speakers had spoken about, is a point in time when over 60% of transponder capacity was being provided to our commercial satellite television and broadcasters who started in 2000. Many will remember the time when we suddenly got television in the way that we know it today, well, young people know it today, on those transponder capacities. And Atmanirbhar in that context is to shift from that canalized mechanism and ourselves launch. So indeed, India has her first owner, operator, and telecom service provider in Tata Plus. You have the broadcaster, which has now got its own satellite, which is using all the transponder capacity upon it. And the only thing now that the service that is being provided, which is ground services, is being provided by the Department of Space, I mean by ISRO or New Space India company. But here, how has it happened without a space activities? It has happened because the satellite was launched and it was transferred on orbit. So it was built and launched by Department of Space, ISRO, and after it went live on orbit, it was transferred. So there was really no need for the purpose of space activities all and how, because it is not the private sector that launched it. So it was overcome through that. I see these 2 years as a realignment of the wheel of our national space program to put it in a format which is now enabled to allow other private sectors, such as what we have been, our song for the longest time, is new space. Companies that have, it's a suo moto emergence, it is completely unconnected with the ecosystem of procurement of the Department of Space. It has built its own IPR and looks forward to providing end-to-end services. The question that then arises is, will we at any time have a policy, call it a mini policy, because that's, or call it a policy framework, call it what you want, just a white paper if you like, to say that yes, we will in due course allow our new space private, just to distinguish between the two, to also allow end-to-end telecommunication services in India, broadcasting services, remote sensing, that's another. And we have yet another emerging company that is actually doing space situational awareness. That's the only company I own on orbit. Will he be allowed to provide services to other commercial or government or whoever wishes to use the services of what is happening on orbit? We have not heard of that yet. Flowing from there, what has, however, happened in consequence of Prime Minister's announcement is that in space, the Indian Space Promotion and Authorization Center has been established almost within days of that announcement. But the role of InSpace, which is said to be for the promotion, hand-holding of new space, which they're doing with aplomb and with great deal of vigor, and many have been able to use the facilities of ISRO. 2 of them are actually tested on orbit, undertaken experimental tests and to prove, and successfully, that has happened. But what after that? So comes the question of space activities bill. To me, promotion and authorization are inimical concepts. They do not sit harmoniously with each other, and that is a problem, at least for me. Unless we say that authorization, it is a word borrowed from Article 6 of the Outer Space Treaty, that it is that authorization is involved in context to new space companies wanting to use facilities and undertake experiments, to that point. But what happens when you want to launch a commercial satellite? Then what are you talking about? If I take an analogy, and Abhishek, you're more than familiar than any of us, is that LOI, letter of intent, is issued by the department, DOT is the licensor, then there is a time gap, all those arrangements are done as per the LO, then a telecom service license is provided. Then you go to the WPC, which is the spectrum regulator, and get spectrum as a consequence of having got a service license, and you get on with the job. That is the mechanism. There is nothing wrong with this mechanism. It has been working perfectly, and there is no reason why it should not work perfectly. Question is that for new space to be able to do that, then there must be a policy framework to say, yes, you will be allowed to do that. This will happen in latest interview said a decadal plan. It is quite likely that within 1 decade, we might have a space bill. But the consultation process cannot be the way that it has been happening up until now. As far as the draft policies that, it is issued, there are 15 to 20 days given. Please send in whatever it is by email to so-and-so, so-and-so, end of the story. I would suggest that the extraordinarily robust consultation process of the TRAI is a very good and satisfactory consultation process. When I was involved with the project pertaining to the Airports Economic Regulatory Authority, where there was one of the five doing the number crunching, so to speak, and my job was to provide the legal framework for tariffs for airports. We borrowed that mechanism from TRAI. That is what was set for ERA, because at the end of the day, they're pertaining to tariffs. And we had extensive written proposal in a person and then revised white papers, and it kept on like this until that final. Ultimately, it is government which will accept proposals or not. I think that sort of mechanism, if we had to have some clarity about how the consultation process will go, how it is envisioned, nobody is holding a gun to anyone's head, to say that, look, generally this is what is the role that we propose for new space to play. It will be really most helpful. Thanks.
And thank you so much. I think that is a great overview of where we were and where we are at and what we are looking forward to. A kind of a segue to that, I think, you know, for any jurisdiction, any state to commence that process of lawmaking, and specifically now in today's times when there has been a fair amount of policy-related discussion and dialogue, and I would say some element of maturity in that process, the process should be ideally, as ma'am also said, that you create a policy which essentially sets out the roadmap. Where do you want to be 25 years hence? Within that 25-year period, what are the specific targets that you wish to achieve within the overall umbrella of being Atmanirbhar? Now, when you say that you want to be Atmanirbhar, there are certain subsets of the manner in which, you know, you would carry on those activities, whether commercial or otherwise, commercial, defense, civil, whatever nomenclature that you adopt, and you put them in those silos. And then you specify as to what will be permitted for the private sector. Within the private sector, what is permitted for Indian incorporated entities and what is permitted where you will allow foreign investment to come in, whether directly or whether through an automatic route or through the permissive route. And then sort of set the ball rolling. Once that policy is formulated, that becomes the basis for then creating a space activities bill or a commercial space bill, as you may call it, which then will set out the specific rights and obligations of parties wishing to engage in, in collaborating with the state to achieve those policy objectives. And then, of course, you have the downstream aspects of the legislative process, which will be the rules and regulations, which will be the more executive or the executing part of the policy and the law. So that's how I understand, what ma'am just said, for us to take in terms of steps. And during the course of this session, we will hear from the other panelists about some of the nitty-gritties of how we think we should go about this. I'd like to now move over to my right to Ashok. Ashok, in the broad background of what Dr. Kaul has just provided to us in terms of how we were, where we were at, about what we are at today and what we want to be, and what, the summary that I provided for that. What I would like you to sort of comment upon is, while we may or may not have had experiences specifically in the space-based applications domain or a satellite domain, but we've had various instances where, disputes have arisen in the context of telecoms or, space-based activities or otherwise, and there are international, because this is a cross-border sort of industry. So from your experience, what do you think are the learnings that we need to take along with us, either at the time of formulation of policy or while we make an act for this?
Thanks, Abhishek. So I think as an advisor to various businesses in the space sector, I have the privilege of hearing what my clients want to do, and then I have the privilege of telling them what they can't do. And this has been my reality as a lawyer for the last couple of years, especially working with the space sector. So let's define the problem statement in the simplest of terms. What is the objective that we are trying to achieve? We want technology self-reliance in the space sector. And to achieve that, we need sufficient amount of enabling factors. One of them is capital, right? So in order to understand the economic element or the trade and investment law element to space law, the one advantage that India has is that we have tremendous amount of experience dealing with disputes. So you have the Antrix-Devas arbitration as a case study to fall back on, the cancellation of 2G licenses, retrospective taxation and their implications under BITs. So you name the problem statement under international trade law, we seem to have sufficient experience of having dealt with it, having won some, having lost some. So we know what exactly we should not do going forward. So currently, what is the problem statement that the law must address? See, the absence of law on space activities is a double-edged sword. For the state, when you have an outer space treaty or the liability convention or the registration convention binding you as a state, Indian law does not enable that international obligation to become domestic law automatically. It has to go through a process of localized rulemaking before it assumes the force of law. Now, till date, before the 2020 reforms were initiated, take, for example, the remote sensing data policy. It did mention what can and cannot be done in the context of Earth observation and remote sensing data. But the problem is that there are no consequences specified within the policy as to what happens if you violate it. Now, a similar question arose under the national map policy before the Madras High Court in J. Mohan Raj versus the Secretary to the Government. And when the violation of national map policy was alleged, the Madras High Court held that, look, even if we hold that the map policy has been violated, the policy does not stipulate the consequences. What is the penalties? What are the fines? So therefore, we are not in a position to enforce the map policy through this litigation. Right? And that was the same pitfall that existed even with the remote sensing data policy. So I think the first thing that the state must understand is that not having clear, unambiguous law can be equally detrimental to the state because you have no means of enforcing international obligations on domestic players. Now take a look at it from the point of view of the private sector enterprise. Let's take a very recent example. When the Russia-Ukraine conflict started, one of the first fallouts of the conflict was a targeted cyber attack against a private satellite service provider whose services were being used by the Ukrainian military. Now, under international humanitarian law, the targeting of a satellite or a civilian asset or a dual-use asset when it is being used in the course of a military activity is legal, right? But so far as international space law is concerned, the rules of what can or cannot be targeted in space, it seems to take a slightly conservative view and says, leave space out of it. Now, which legal position should prevail? And imagine the plight of the satellite service provider. He thought that the military customer is going to pay good money, and he started servicing them, not realizing that in a military conflict, his satellite is going to be targeted. So does the indemnities with the contract with the customer cover this kind of a risk? Does the insurance policy cover the kind of damage that arose in the course of a military activity? Because you also have force majeure clauses that exempt any kind of consequences. So today, the world that we live in, there is a convergence of political, economic, business, and military all coming together when it comes to space activities. And this is the scenario that rulemaking has to address. So going back to the problem statement, technology self-reliance and the flow of capital, the first thing that we need to realize is that a good, predictable, and clear legal framework also attracts international capital to come into the country. And fairness in how we treat those international investments determines how lucrative a destination India becomes for attracting investments in this sector. And there is a lot of damage for us to correct because the 2G spectrum, the license cancellation of 2G spectrum licenses, as well as the Antrix-Devas has left a very bitter taste in the investment climate. Number two, and I think this is very, very important, the DOS and the DOT have a shared regulatory function when it comes to authorizing a space-based service. So the space segment capacity is, in principle, approval happens at the DOS. The spectrum assignment, the frequency allocation, the licensing under the unified license, everything happens at the DOT level. This entire process, in practice, based on a tri-consultation paper, takes about 7 to 8 months to reach fruition. Now, this deadline is not specified in the law itself. So if a foreign investor has to look at how long it will take for an investment in the satellite segment to actually reach operational readiness, we don't know on paper what the deadline is. So this is a problem that needs to be addressed. The second big problem, when our bureaucrats have to take a decision on a new application, there is tremendous amount of baggage that they have to deal with. Take a look at what happened in 2G spectrum cancellations. The allegation was corruption. Criminal prosecution was initiated against a lot of the people involved, all of which have more or less resulted in acquittals. So which means the foundation for cancelling the 2G spectrum licenses, which was corruption, there is no corruption technically in the eye of law. So the result is that tomorrow the entire cancellation was completely an unnecessary exercise. So what we need to do is to empower our bureaucrats with a law that they can fall back on, where tomorrow if their decision is questioned, they can go back to the law based on which they've taken the decision and say, look, based on this, I have exercised my discretion. And for that, what you need is a very clear framework for delegation of powers within the parent law. So my assessment of what needs to be done is slightly different. I feel that we first need a legislation. The reason why I feel that we need a legislation is because it is much more stable compared to an executive policy which can be changed quite frequently. So it gives that additional layer of confidence when the method of rulemaking is a legislation and not a policy or guidelines or rules. Number two, the legislation will obviously have to account for the kind of decisions that bureaucrats will have to take for authorizing a space mission. This means that the law must clearly specify what are the parameters based on which an application for authorization will be adjudicated. It should list those 10, 20, or 100 items that if I, as a service provider, fulfill, I know for a fact that I will get my authorization, and what authorization has been given to me, I know I will not have that authorization cancelled or that license cancelled unless I do 10 or 20 things that I'm not supposed to do. I think this is very, very important, because the moment the parameters for delegating powers to an in-space or a DOT or a DOS becomes clear, then the people who have to take decisions, they will not have to think twice about taking those decisions. And today the delay on adjudicating some of these applications for licensing or authorization, or perhaps the uncertainties involved in the process, comes from the mind of the officer who says, if I say yes, and tomorrow there is a scandal, what is the safety net provided to me? And I think unless we have that empathy for them, we will not be able to solve this problem. Number two, we have to realize that regulating space activities is not just about space regulations alone. It's also to do a lot with non-space related matters. Ease of enforcement of contracts, freedom of commerce, international trade and investment obligations being translated into domestic law. These are some of the benchmarks based on which we will know whether the space activities bill or space legislations will actually serve the purpose of attracting international capital and ensure that the flow of investments into this sector is seamless and the law does not become a hindrance but becomes an enabling factor. So to understand what needs to be done, all we have to do is to just go back and study some of these arbitral awards and judgments that have gone against us. Antrix Devas was not a case where the arbitral forum said India does not have the right to regulate its S-band. All it said was that your decision should have been clear from day one. You should have notified the investors on time. And because you delayed the notification and on the strength of the delay, some investments were already made. That is why the BIT obligations were found to have been violated. This is not a very difficult problem to solve going forward, right? So a lot of good things have happened. We are clearly not a country that does retrospective taxation anymore. There was a very nice announcement recently that said in high value investments, the advisory jurisdiction of the Supreme Court will be invoked for telecom licenses so that we don't have a repeat of the 2G spectrum cancellation that happened. These are some great steps. I think we need to build on this. I think we need to codify this into a legislation. We need to have a clear demarcation of delegation of powers. We need to lay down the parameters based on which space activities will be authorized. If we get this right, I'm very confident that the slated objective of technology self-reliance can be achieved seamlessly. Thank you.
Thanks, Ashok, for that wonderful summation of how we can possibly use the roadmap from, learn from our mistakes of the past, possibly in other sectors, and try and assimilate that into some sort of a legislative guidance so that the implementation of that gets clarified. There is a clear mandate to the decision makers that they need not just pass the buck or pass the files and ask every matter to be litigated in court for it to reach a particular conclusion. And interestingly, you pointed out that perhaps rather than having a policy first, we should have a legislation that sets out the rights and liabilities very clearly, and that becomes the basis for the decision-making process. We do have examples of that. I mean, we had all the intellectual property legislations coming into force between the 50s, the 70s, and then further being overhauled in the early part of the last couple of decades ago. The policy came in only in 2015, or at least the draft policy came in only in 2015. And a lot of the legislation, or at least the amendments thereto, mirrored our obligations under TRIPS and other international sort of treaties. So I completely agree that that is one way of going. I think as we lawyers always do, we will have our different points of view in terms of how the process should be gone about. Perhaps the reason why I would think that both should be happening in tandem and in parallel is because of the fact that there is a need to set the tone for what the government or the state wants to achieve, at least in this sector, and thereby do that achievement through that the space activities bill. Another thing that you pointed out, which is interesting, is the issue that arises in the executive decision making in the absence of a law, and where there has to be a reliance on an open-ended sort of policy statement. I think that is where regulators, and I think Dr. Kaul alluded to that as well, regulators such as the TRAI will be extremely important as, if I can use that particular word, bouncing boards, because they have recommendatory powers. There have been decisions time and again of the constitutional courts of this country where they say that, at least under section 11(4), the transparency that is required to be followed in the process of consultation is what sets apart the regulator from the purely executive government arm. So when we have the availability of that expert body, and if there is a need to expand the scope of activities or the recommendatory powers to be given to such expert body, I think we should be doing that. Unfortunately, the telecom bill as it currently has been tabled, or at least put up for consultation, seems to be doing something totally the opposite. And while we've heard statements in the press to say that power is not going to be whittled away, and perhaps there's going to be a relook at that, let's see, only time will tell. Thank you for that, Ashok. So we'll move on to Arjun. Sorry, this side. So Arjun, I think we've given a fair amount of inputs to the audience in terms of the past, the present, what we anticipate. There are differences of opinion to a certain extent between Ashok and I on what path should be followed, whether it should be policy followed by law, whether it should be the other way around, whether it should be in parallel. I think some of the nitty-gritties of how the business is to be carried out, and what the licensing regime should be, what is really the ask of the businesses when they are looking at setting up the business in India in this particular realm. I think you've had some experiences in that regard, and we'd like you to share those with us.
Absolutely. I think I do agree with parts of what Ashok was saying, that it is the responsibility of the state to create a framework that is investable. So everybody should have confidence in saying that I will enter the Indian market and not have a situation where 10 years, 15 years later, everything stands cancelled and I have to write down my investment back to zero. That is, I would say, the primary responsibility of the state. The secondary responsibility which the state takes upon itself is, I will also be in the business of doing many of these things. In those cases, maybe it needs to take a step back, saying, I will be one of the many players doing this and not the only player doing this. It can't be a monopoly player in many of these activities. And if the state's objective is that we need to be a country where we have a vibrant private sector in many of these activities, whether it is launching satellites, telecommunication services that rely on them, and a vast network around it. The primary thing it needs to be able to do for the private sector is just make it at the first level easily investable. Today we have a framework where making investments in these sectors are highly regulated. You need approvals. I personally don't see a reason for having that kind of a framework. At the end of the day, everybody should be allowed to invest in the sector. It is the government's prerogative on whether the invested entity is, the government chooses to contract with it or not. But why do we need an FIPB or whatever FIFA approval to invest in the space sector in the first place? It's not like we haven't had businesses that are promoted by Indians. It's just that we've had situations in which they've had to create overseas holdco companies and create those structures to achieve the same outcome. So first is we need to just allow free investment, whether it is in space, whether it is in associated areas like, for example, defense and that list of defense equipment, and then it just becomes a prerogative of the buyer on whether they buy it from them or whether they make it available for the free investable market overseas. The second, I think, framework is we need to understand space will become an infrastructure layer for many services, especially telecommunication services going ahead. So there may be many players who are just in the business of providing a network and providing a satellite, but they don't want to be in the downstream business of doing services. And today our licensing framework is infrastructure plus service, both, right? We don't have split licenses. And we've seen examples of the world over where we have pure infrastructure licenses, class-based licenses of being able to set up an infrastructure locally, be able to receive service, and then resell that service to other infrastructure players. So that again may make it very easy for a quick transition from, just few players in the sector to many more players who are being able to provide services in the sector. And the third aspect I would say is and that's more also in the sense of perceptional, and that's, in this conversation or, any sort of defense sector conversation we see, there's a perception within government of seeing private sector as sort of MSME or small and medium enterprises, and therefore and that mindset has associated consequences with it, right? Then you start thinking about what is our small and medium business, whether it's owned by Indians or whether it's not owned by Indians, and then creating special classes or frameworks for it. That's really not how capital flows, right? If somebody is setting up a space business today, they don't do it with the perception of saying that, I will be a small and medium business and I'll provide some services. They want to create a large business. To create large business, you need a lot of amount of money. Most of that capital does not reside in India. So you need to be able to have a vision that you will be contracting with, players who are maybe promoted by Indian parties, but have a large amount of foreign investment and therefore don't meet your thresholds of 50% owned by foreign players or things like that. But that is just a perceptual change that needs to happen within government on when they're looking at Indian entrepreneurs and they're looking at contracting terms for Indian entrepreneurs to provide services. And we need to be more flexible and free on that aspect. So I think just these three aspects.
Thanks. A fairly succinct summary of in terms of the to-dos that we require to sort of implement. So since you spoke about entrepreneurs and since amongst this panel, we have someone who works very closely with entrepreneurs, that's Keyur. I'd invite you to share your thoughts. We as lawyers, external advisors, are only going to be telling you, as Ashok said, that you can't do this and you can't do this and you can't do this. But it's you who are answerable to your founders and to the promoters and to the investors as to why is it that you cannot do it and what are those challenges. And I can't hear no for an answer. You have to figure out a way to do it. So over to you to explain to us as to how you navigate these challenges.
Thanks a lot for that, Abhishek. So I think taking cue from what you said, I actually don't have an option of going back and saying, no, we cannot do this. Because for businesses, it's 5 small questions, right? What can I do? When and how can I do it? Who will let me do it? And at what cost? Now, this brings me to a very important perspective with which we look at law and regulation across the globe, not just in India. It's from the perspective of market access. Whether I can bring my technology, whether I can bring my products and services into any particular jurisdiction. Today in India, we've seen quite positive signs in terms of where the Space Act is headed. yet to come, but it's headed in a good direction. And why do I say that? Because if we take some cues from the satellite reforms that were announced a couple of days back, we see that accommodation is being made to provide end-to-end services, like Ranjana ma'am was pointing out. It has happened for a very long time by the government, but we need to make way for the private sector to come in and let that happen. But when we look at it as startups, the issues are very different, right? If we look at who has been a telecom service provider for the last 3 to 4 decades, it's people who own geostationary satellites. Their economics are different, their designs are different. The way they conduct their business is a lot more different. To again cite Ashok, I think from the policy, it is evident that there's 6 to 7 months that we should expect for the entire approval timeline to go through. Non-geostationary satellites which fly in the low Earth orbit probably have a mission life of about 3 years. So that means each time I launch a satellite, about 30% of my orbital life, when I could have been making money, is the time that I would end up spending trying to coordinate on spectrum, get approvals, look at services, and all of this in a developing market. When you're looking at customers who are yet to adapt to satellite-based services, there's a book from which I did learn a lot of lessons early on when I started working with Dhruva Space. It's the eccentric orbits, the Iridium story. If you look back at the kind of questions that were posed to Motorola when they were trying to launch this service, you would find that technical understanding by the regulators was one of the biggest challenges. We can, of course, learn from what has happened in the past, but that cannot continue for this one very simple reason. When, if you would ever read up on what were the spectrum access challenges for geostationary satellite owners and operators, you would hear about something called as orbital slots. That is not a challenge for us. For us, the challenge is a whole lot different. We have about 600, maybe in the future 6,000, and maybe 60,000 objects in the future flying around in the same orbit. Spectrum is scarce. There's a way to share it. There's a way to coordinate it. But that in itself is a time-taking process. And it has its own process in each of the countries. So what's the real need when we look at answering the questions of what can I do, how can I do it, when can I do it? The answer is one, it's harmonization. Everyone needs to get on the same page, because unlike a geostationary satellite, a non-geostationary satellite goes around the globe once at least every 90 minutes. That means with a constellation that is made and launched from India, you can actually provide services globally. But would that happen if I'm not allowed to access the markets or provide services on the same technical parameters, on the same specifications, at the same cost? And what is to be seen is, who will we pass on the cost to if we are not able to access other markets, or if other players are not able to access our markets? The lesser is my commercialization globally, the more is the cost that I pass on to the end customer. And I'll take some more cue from the inaugural session, where you would remember that citations were made to say that in India, space is not just an issue of building the next SpaceX. It's the issue for social development. It's an issue to promote inclusion. It's an issue to promote access to geospatial data for urban planning, for national security, and a lot more. So we need to think about all of these issues together and then find out answers to these questions. And like my good friends in the panel pointed out, these answers won't come from the Space Act alone. They'll come from what is the telecom regulation. They'll come from what is the FDI process. They'll come from what is the export control regulation. They'll come from what are the limitations to someone being eligible for public procurement, what is the how they are treated, from the defense acquisition procedure, from rules of procurement of goods and services for the central government, and a lot more. So when we talk about it from a startup's perspective, it goes a lot beyond Space Act, because what will I do with the satellite once it is in space is what would be of consequence to the nation and to the development of the whole ecosystem in India. I Hope that sums it up.
No, thank you so much. I think we need that from time to time. We need to get out of our, chairs and esoteric sort of conversations about what an act should have and what policy should have, to hear from you, people who actually we would like to service or we are servicing, to hear what challenges you face and how we can provide solutions to it. So, the points all well taken, and hopefully that some of the aspects of the legislative process and the broad terms of navigating the law, which this session is discussing, will certainly should take into consideration the inputs that sort of you provided. Moving on to Rahul, some of the aspects that we've discussed and specifically what Keyur mentioned are challenges that need not be specific only to the space domain, right? I mean, like Ashok said, that we've learned some of the mistakes that we've committed in relation to 2G spectrum and the bilateral investment treaties, etc. I'm sure at the regulatory and policy level, because of the fact that it involves whether it's the broadcasting space or the telecom space or software. I mean, we've had a lot of these success stories where there was at one point in time, not too far ago in the past, complete monopoly by the government, and that was then slowly transitioned to the private sector. So what lessons can we sort of learn from that to implement in relation to the space businesses?
So thank you, Abhishek. So Abhishek, largely, if I look at the journey, let me go back in time. And when I was a kid, I grew up watching Star Wars and Captain Kirk, Captain Spock. That was always a very fascinating idea to talk about the space, outer space exploration, and eventually we saw the movies coming in like Back to the Future, which showed us video conferencing. And those were the times when India was actually talking about MTNL, BSNL, getting the phone connections was a challenge. The lineman was my lord's, he was the most precious commodity in the market. Getting the phone running 24/7 was a big thing. So, we have grown, and seen those times eventually. Then in '84, we saw Wing Commander Rakesh Sharma going into outer space. Absolutely fascinating for Indians. His, maiden reply, "Sare jahan se acha Hindustan hamara," is like something which is iconic. Every kid from my generation possibly would remember that. And the journey, began from there. And when we started talking about the space, and eventually when I grew, I became a lawyer. Wanted to be an astronaut, but I realized that you need to be Indian origin person to be into outer space. Rakesh Sharma was one exception. But now I think with the Prime Minister's announcement 2 years back, and Dr. Kaul talked about it, I think things have changed. I see a very bright future for young generation. I see a future wherein the enterprises, entrepreneurs, startups, big and small businesses, foreign investors would come into India. But the real challenge is that while we are talking about all this, and having this Congress is a great thing, while we are talking about all this, and we have already discussed some of the pitfalls from the previous legislations, the important aspect is to have clarity and certainty in terms of whether it's a political will or the legislative framework. Now, there is much to learn from the previous enactments of certain legislations, the way they were implemented, and how those delays costed a lot to the economy, to the businesses, to the startups, and to the entire ecosystem. Well, not long back, when we talk about TRAI, when we talk about the telecom sector, I think the telecom sector also went through a great phase of evolution, starting from the Department of Telecom Services, creation of Telecom Regulatory Authority of India in 1997, and then the challenge to the separation of powers and the role of TRAI before the Delhi High Court, and subsequently creation of Telecom Dispute Settlement and Appellate Tribunal, TDSAT, in 2020 by way of an ordinance by the Vajpayee government, gave a very good understanding as to how the separation of powers and as to how the government departments, the regulator, the licensor, and the adjudicator have to function. with the creation of TDSAT, it became very clear that DOT would act as a licensor, which is Government of India. TDSAT would be the adjudicator, and TRAI would be the regulator, and they would have their own roles, set roles to play. And that brought in a lot of clarity in the entire telecom space. And I think what we saw post 2000, the growth in the telecom space until 2008, 2009, and then subsequently, until the 2G scam happened, that was phenomenal. And that was phenomenal because of the clarity in terms of the legislations, the way the legislations got developed, and the judgments that were passed by the courts in those domains, including the fantastic work done by the TDSAT in that 10, 12-year period. Again, the framers of certain legislation, the parliamentarians, I don't think that they learn a lot from the previous mistakes. Then we saw, as another example, we saw Competition Act, which was introduced sometime in 2002. The Competition Act was passed by the parliament in 2003. Then there was a debate about the separation of powers even under the Competition Act. The matter went to the Supreme Court. It was there in the Supreme Court until 2007, when the government realized that there has to be again a separation of power by a regulator, and regulator cannot adjudicate everything on its own. And therefore they came up with the solution of having, again on the lines of TDSAT, an appellate tribunal, which was called Competition Appellate Tribunal. Finally, the Competition Act got notified in 2009. But imagine, 7 good years were lost in the entire process because the matter was before the Supreme Court. Who suffered? It was the businesses, small businesses, medium businesses, who suffered because of the entire delay in the implementation process. Now, whether we come up with the legislation or whether we come up with a policy, but I think the important aspect here is to have a clear-cut roadmap which should be brought before the businesses, before the investors, to bring in that kind of a certainty. We cannot afford another 7 years of litigation if the space, any of the legislations governing space were to come out without any clarity. It would be a huge loss of time and potential for the businesses. As an Indian, as a practitioner of law, I would like businesses to grow with a clarity in law. I would not like them to waste their time before the court of law seeking clarity in terms of how the laws have to be implemented, what would be the adjudicatory process, whether Department of Space would have the power, whether InSpace would have this power or that power, whether InSpace can do this or not, whether InSpace is now creating a monopoly in terms of some other entity, whether the government entities or the PSUs or the entities which are already operating in the market would become the monopoly players. Now all those aspects have to be dealt in some manner through these legislations and the framework. We have also seen under the Competition Act recently that institutions such as Indian trade promotion organizations were scrutinized because they were the monopoly players in India to do the conferencing and the similar kind of trade promotion activities. So largely there has to be some learning from these previous mistakes that we have committed to bring out a clarity in terms of how we operate. Also, I think a lot of, in the recent past, we have seen the emerging technologies have also been under tremendous litigation and scrutiny by the Apex Court, Supreme Court, and other high courts in India. I don't think that it's a good situation for us not to have a clear framework, because if that were to be the case, then all these matters would land up before the high courts in some form or the other, which would delay the implementation of the laws as well as growth of the businesses across the platform. We do have OTT social media space. There's a huge debate going on whether the OTT social media space would be governed by the Information Technology Act, the carriage, whether Ministry of Information and Broadcasting would have control over the carriage. And as an example, when the market was liberalized, we created Prasar Bharati with a clear intention of having a regulatory function to be set out into a completely different entity. So I think these would be the broad parameters which have to be looked in when we are looking at framing any of the legislations, so that we don't waste much of time in terms of constitutional challenges, and there is a lot more clarity given to the businesses. And looking at the competition which is coming up in this space, I think the first mover advantage would always be there. I think that we are, although we are late in terms of opening up the sector, but I think the creation and the implementation of the legislation has to now happen at a very fast pace.
Thanks, Rahul. I think that clearly demonstrated the angst that perhaps your clients may have felt in trying to navigate the tricky issues of competition and the other sectors. But just to add perhaps a slight bit of a positive twist to that, what we have seen in the last, I would say, 30 years, where we've seen the opening up of the economy and various sectors coming up. We've had huge success stories in the software, the telecom, the broadcasting, and other domains. That the Atmanirbharta principle, I think, was fairly ingrained in the mechanism or the method with which governance was carried out. It is just that Atmanirbharta prior to liberalization meant that the government will be doing everything to enable everything to be made available, which could possibly be made available within the country. That concept has undergone a minor change where the Atmanirbharta or the self-dependence, you don't have to depend on anyone else, can be translated very well with the growth of capital and the commercial sort of organizations which are non-government. And it all has to do with encouraging businesses in India, whether those that are completely homegrown or those that have got investments from overseas, to be able to provide for those solutions from within the country, not only to be able to service the needs of the country, but also to be able to be in a position to take things overseas. And that's where some of the elements of what we've discussed perhaps can be jointed, including what Keyur said about the export control mechanism, some of the issues that are raised by countries to whom exports are made. So I think all in all, we have had those instances where the government has been a regulator, licensor, competitor, and then left that space of competition open to the private sector and just remained only a licensor or split that function into two separate sets of a regulator and licensor. And perhaps that's the way that we are envisioning the government activity to sort of take shape even in relation to space business. One area where at least a lot of perhaps even lawyers, Ashok being the exception, have found a challenge to advise clients on is on tax aspects. And that's why we have an expert here today on our panel, Hardik. We'd like to hear from you as to what is the regime with regard to taxation in relation to the space businesses.
Thank you, Abhishek. So I guess while I was listening to my fellow panelists, seems to be all lawyers and have a different view on the policy and the approach for the regulatory framework. But being an only accountant on the table and discussing about tax policy, I think everyone will be on one page as far as the expectations from the tax policy is concerned. So last 2 days, we have been all discussing about the opportunities and the business potential which the space has to offer. And as an accountant, as a financial advisor, we may call it as a space economy. And whenever we talk about economy and commercial exploitation of space, on the other hand, you have Ministry of Finance, which talks about collecting taxes on the commercial exploitation of any of their assets. Couple of years back, the definition of India in the income tax law was amended to cover land below, that is seas, and even the space above. So therefore, any activity or commercial exploitation below or above is all subjected to tax, at least from an income tax point of view. So that's very, very important today to note from a tax policy standpoint. What do we expect from the tax policy? I think the expectation from the tax policy is clearly that, one, it should be in alignment with the regulatory framework, the business nuances of the space economy, and also provide ease of doing business. Some of the finer aspects would be A, that the tax policy should act as a financial enabler. It should assist, facilitate, and promote investments and bringing of capital inflows for capex or for manufacturing facilities in India. And B, more importantly, is the tax policy should be clear, consistent, agile, and should keep in pace with the nuances of the business and the way it develops and progresses over the period of time. Now, when we ask for a progressive tax policy, or when we ask for tax policy which acts as a financial enabler, is this something very radical? The answer is no. In the past, in last 75 years, almost every industry or sector has got some or the other benefit out of the tax policy. For example, textiles, there was no tax on garments for a couple of years till it moved into GST. You talk about infrastructure, you talk about SEZ laws, then more recently you talk about the e-commerce regulations. And the recent one is the IT/ITES services, the BPO, KPO services, which got a lot of benefit or tax holidays in the corporate income tax. So is the ask fair? I think so, yes, the ask is fair for the space economy to grow with the numbers which I was reading in one of the newspaper, that globally it's going to be a $600 billion economy by 2025. I'm sure tax policy plays a pivotal role in uplifting and giving that fillip to the economy. Now, going further into the nuances, when we talk about financial enabler being a tax policy, let's look into various sub-segments of the space economy and the whole ecosystem as such. Let's look at research and development in space technology development, particularly for the defense as well as for commercial. Today, the tax laws provide certain weighted average deduction for research and development expenditure incurred by corporates. I think it may make sense to give a higher weighted average deduction for making any expenditure done for either defense or even for commercial research and development for technology. Second is manufacturing in India, that is to promote indigenous manufacturing under the Make in India or under the scheme of Atmanirbhar Bharat. Recently, we might have heard the huge production link incentives or the so-called PLI schemes which are announced by the government of India through the various ministries by way of an allocated budgets. The reason for the sector which is very close to the space economy is the telecom, where similar PLI scheme for promoting manufacturing in India was also announced for telecom equipments and network equipments. I think it makes sense also to have a PLI scheme similar for the space economy, particularly for promoting indigenous manufacturing of small satellites, satellite bus, and probably that will also help us give a lot of push towards exports. Also, we need certain PLI schemes or incentives for ground equipments. A lot of critical equipment still today are imported from outside India, such as high-end cameras. While there are facilities which manufacture them, but still we are still import dependent. A lot of concessions around such critical equipment which are required for manufacturing satellites would be a good idea. Secondly is to have a lower corporate income tax, perhaps. Yes, there are now two policies where there are lower corporate income tax for setting up of new manufacturing facilities, but particularly if someone wants to set up a manufacturing facility in which is related to the space economy, and again, while I'm loosely using this word space economy, there is no definition of space economy, and it will all depend upon how the interplay of the tax laws will be with the regulatory laws. So anything related to that and having a lower corporate income tax or tax holidays like we had for IT and ITES would also give a good fillip to the manufacturing business in India. One idea which has been going around in circles is to have a space tech park. Okay, this idea is very much similar to the SEZ laws or the IT/ITES park or the food park. Similar park or a space tech park can be created, which could actually bring in the entire ecosystem of vendors, suppliers, manufacturers, service providers, application developers in one park, and accordingly will bring in the synergies to lower the cost of production and lower the cost of services. So similarly, we have like, for example, we have automobile belts in Pune, we have automobile belts in Haryana, we have automobile belts, OEM belts down in South. So similar space tech parks, if are also being thought and being planned, and again, if regulatory framework also provides those framework, I think it's a brilliant idea. Then for startup and MSMEs, there are more than 100 plus startups with a business potential of about $70 to $75 million by 2025. I think startups need a lot of support. Any tax holidays, any benefits, concessions given to the startups would be really good. Satellite launch services, this is also really important. Today, the satellite launch services are being provided by ISRO, by Antrix and NSI. They have certain tax exemptions from GST point of view. But we see a lot of private players also wanting to launch satellites from India. So any tax holidays or exemptions for launching satellites would also be beneficial for the overall space economy. Setup and testing facilities, today we have only one testing facility, which is by ISRO. And I'm sure there are more private players who are interested in setting up testing facilities in India. And again, any tax benefits given to such testing facilities by way of any subsidies or rebates or incentives would again do good for the economy. Now, on the tax policy side, as I said, it has to be agile, it has to be progressive, and the whole ghost of retrospective taxation, while it's not there, but the telecom sector, which is closest to this, has really lived to it, and it's still fresh in the mind. So I think the tax policy needs to be very, very robust and vibrant, and has to keep pace with the developments in the space economy. For example, today there are various issues and concerns, particularly when we talk about applicability of GST. Now today, let me give you one classic example. Suppose if an owner and an operator is based in country A, the satellite of that owner and operator is in orbit in country B, and the receiver of the services is in country C. Now which country will tax that? Country A, country B, or country C? Or all of them will tax in a proportionate or in an apportioned manner? So there are some such issues, both from a GST and even from corporate income tax point of view. And if you were to continue this, today GST talks about services provided by fixed lease line, fixed telecommunication network. There are no maybe enabling provisions to talk about how the services will be delivered and how the tax has to be collected, which state will collect tax. Whether the satellite is orbiting around Maharashtra, Gujarat, MP, which state? I mean, it can't really practically be done in that manner, right? So there are certain changes which are required in the law to keep pace with the changes in the space economy. There are foreign players who are wanting to set up business in India, want to invest in India, want to also have their own, maybe a branch or a subsidiary in India. There are issues around permanent establishment, particularly when the fact that there are certain base stations, transponders, etc., which are, or network equipments being installed in India, expats coming in India, working in India, whether that would create a permanent establishment, whether there will be any trigger of tax liability in India for corporate income tax. Those are some issues which are still fresh and are required to be addressed. Certain other issues such as withholding tax, how the payments will be taxed, whether it will be taxed as royalty, whether it will be taxed as fees for technical services. Again, the rate of tax also differs. And recently we have seen a lot of customs issue around import of network equipments, and any decision here and there about the duty concessions, okay, can actually make or break a project. Okay, today if you import, you pay a duty, you claim a benefit of a notification, you pay a duty of 5%. But tomorrow if that gets disputed, that dispute, I am sure, will get settled at Supreme Court by that time. And if the higher rate of duty is at 20%, your 15% straight away hits your margin or the bottom line. So these are certain important aspects where we believe that we need some clarity. And I'm hopeful that with SIA, we should make strides, collectively should make strides in having the right tax policy and an environment which is suitable and conducive for developing the space economy in India. Thank you.
Thanks so much. And it's quite interesting that the policy announcement in the middle of May 2020, which was made by the Government of India on boosting private participation in the space sector, was made by the Finance Minister. So that's why I thought it would be interesting to get a finance stroke tax perspective to this entire industry. And you know, as Hardik mentioned, very often it is a rate of tax or the incidence of tax that can perhaps make a decision of whether or not to proceed with the business. So I think if I am to summarize the discussion, I do know that there is one particular point that we left out. So before I provide that summary, I just want to ask Dr. Kaul, in terms of the treaty obligations from the Outer Space Treaty standpoint, what exactly, I think there is a lot of ambiguity around, and I'd like you to dispel that.
Well, thank you, Abhishek. That is an extremely pertinent question. Whatever we have spoken about today, right here and now, excepting for Hardik, who actually also spoke about the defense space sector. Important thing to remember here is that, and also the fact that very high government functionaries through the morning in the session that was chaired by General Khandare, who's sitting over here, were actually quite openly speaking for the first time that I have heard that outer space is the fourth war-fighting domain, and that defense space is a cardinal pillar in addition to commercial space. Now here's what I want everyone here to remember, and especially for those from the uniformed services. The Outer Space Treaty being the ex cathedra international arrangement for how space activities would be governed and undertaken. Remember, at the relevant point in time, there were just the two superpowers, USSR and the United States. And starting life with V2, as Air Vice Marshal Koch said in the morning, and within 12 years of having acquired the human assets post the Second World War, that is to say the German engineers, so forth, that had helped design and realize V2. The Soviets took whatever they could get, and the Americans, under a mechanism they called Operation Paperclip, took 104 of these from Germany, and you know, they got new identities, so forth. And within 12 years, you had Sputnik, which was a military communication satellite, the world's first, and by December of that year, 57, you had India, the world's first continental ballistic missile. But immediately after Sputnik, the superpowers decided that, you know, there was no value to doing a bilateral treaty for the very reason that, you know, tomorrow I may not like you anymore, and breeze off, you wouldn't even know post the event. Second is multilateralism also did not recommend itself. They'd gone through First World War, Second World War, and many before that. So they said the thing to do is to go to the United Nations. Both superpowers are not engaged in any form of altruism here. They want to continue developing military technology. Both want to do it, but neither want to be gypped out of, you know, where one takes a flag and says, well, ye to ab mera ho gaya. So they don't want that to happen. They don't want a situation where they are both now engaged, they have agreed to engage in outer space, that one decides to attack them on land. As a result of all of these concerns, and also keeping in mind that the cardinal space resources, which is spectrum, orbits, and orbital slots, and I'm talking of Earth orbit, because you know, nobody had actually thought about going to the moon at the relevant time, was already being governed and regulated by the International Telecommunications Union. The International Telegraph Union is a creature of the 1860s. And by the 1930s, it had already metamorphosized into the International Telecommunications Union. So the superpowers knew that nobody is going to be disturbing the natural resources, which are cardinal, without which, in any case, you would not be able to undertake space activities. What was the third element? It is actually undertaking the activities. Now, how do you undertake that activity? You put a man-made object, and in that you embed technological platform, technology platform, and you know, purpose it for whatever you want. That is the genesis of the Outer Space Treaty. The Outer Space Treaty, even if it says for peaceful users, and nobody is asked, what does peaceful mean exactly? By default, and as our country's decision at the time, we had decided to start a national space program, which would be a civil space program for the purpose of economic development. Remember, when India gained independence, it was only the British provinces, 1/3 of our landmass. The rest was under the control of sovereign princely states. It took several years for India to become the India we know today. So the job was for the government of India, how do you connect everybody? Our concerns were way different than countries that were not in similarly placed situations. Be that as it may, the Outer Space Treaty, which is the outcome of the Cold War, is applicable to all space activities, military and state, whether they be undertaken for civil purposes or for commercial purposes during peacetime. The minute you're in a state of war, one country is declared a war against the other, everything gets suspended. So the application of the laws of armed conflict to any given situation that may be happening, which in today's world, especially after the first Gulf War, which was the first time that all military technologies, space technology developed by the US armed forces, was brought together and embedded in the armed forces to use, and therefore you got the term force multiplier. That time, which is to say 1990 or 91, is exactly the time you coincide with the fall of the Soviet Union, when Mr. Gorbachev was overthrown. And suddenly the United States finds itself as the only Superman and allows its military technologies open for commercial purpose. That is how we got commercial space, and where India is today is trying to see how they can, chip into that commercial space, which is a humongous business. And I think in December 21, it was 469 billion, the space economy. We have, if at all, a very minuscule part of it. And that's the effort that, fair enough, we've come late, but we have a very robust space program and capability. And so therefore, I want it to be always remembered that Outer Space Treaty governs military and state activities. By that measure, when we have a space policy, a draft space policy in a final version, and or we have activities bill, it must necessarily be very carefully vetted, not just by the Department of Space, but by the Ministry of Defense and by the Ministry of External Affairs, which are our bureaucrats who stand in the Committee on the Peaceful Uses of Outer Space, represent us in Conference on Disarmament and various other UN organizations. This is cardinal. So therefore, this exercise is a Government of India exercise. And it must be taken forward in that way so that we do not interpolate our own feelings about, space debris and suddenly find ourselves putting liability for environment, which was in the 2017. Because environment, why? Because you should not put debris, then you shut down your space program. Every man-made object, there's no such thing as a good space object and a bad space object. Like there's no good terrorist and bad terrorist. So we have to be extremely cautious now that we have accepted that defense is most definitely there on India's map, which is to say defense space policy. We have to be extremely careful. We cannot do anything and shoot ourselves in the foot.
Thank you, ma'am. So if I could just try and summarize the thread that bound all of our inputs in this session is, A, be mindful of our treaty obligations and international obligations, and also the background to how it comes about. B, have a policy to set the roadmap for where we want to be. That policy need not precede the legislation. It can go hand in hand. It can come simultaneously. It could also possibly come a little later. But there needs to be that policy to lay the roadmap for the next 25, 30, whatever years. Have a very clearly and well-defined set of rights and liabilities in the proposed space activities legislation, which is a must, because that will set the tone for how you carry out those activities. And lastly, have a collaborative exercise. And yesterday I was in a panel where we were talking about collaborations, and of course it was more about industrial collaboration. But my sort of input on that was that the collaboration needs first to be done at the interministerial level across the various stakeholders who will not only participate in that process, but also get impacted by the outcomes of exercise of those rights and obligations. Thank you so very much to all the panelists. It's been a great session, and I hope the audience sort of got some takeaways from that. We have very few, I think we have only 5 minutes left. Yes. Yeah, so can we have 2 or 3 quick questions? Yes, please.
Thank you very much for that enlightening session, and it was a masterclass in law, especially for people from the tech sector who do not usually get such kind of masterclasses in our classrooms or in the labs. So my question is that there are quite a few nebulous issues that need to be addressed, which are not pertaining to the orbital slots or orbital activities, but more so about the cislunar activities that are coming up. Firstly, I won't go to Artemis Accords, ma'am, but firstly, last year in December, the US Congress, they passed an act quite innocuously named as One Small Step to Protect Human Heritage in Space Act. Now that act speaks about how the US would commit itself, or the US ecosystem will commit to preserving the artifacts that have been laid on the moon since the times of Apollo. Some 10 years ago, the same US Congress had tabled a bill which didn't get passed, that was called as Apollo Lunar Landing Legacy Act. Again, speaking the same stuff, preserving of artifacts and creation of national parks on the moon. Now, how is that possible under Outer Space Treaty? We are signatories to the Moon Treaty, we have not ratified it, but again, it is a matter of global commons. How do national parks come in global commons? Thank you.
The Outer Space Treaty is an international treaty document. What a country does within its own jurisdiction is quite another matter. It is its sovereign perception. So if that country feels that, Apollo landing site is the ultimate for the citizens of the United States, well, it must be. Just as much as our, wherever it is that we have put the India flag, the photograph of it is very important. I would like to take my grandchildren for a weekend. So I'm very happy if India passes such a law. However, here's the problem. There is an NGO in the United States. It is called For All Moonkind. The lady who has established, she and her husband, were also from the Institute of Air and Space Law, not my contemporaries in Montreal. And so she got in touch with her professor, who was also Ram Jhaku, as it happened at the time, and said that, I want international representation on the various committees, and so therefore legal committee, and India is a very important country, and so forth, so forth. So she got in touch with me. I said, I rang up Ram, and I said, look here, you have, what is all this? He said, nahi, tum karo. I said, all right. So I did, and I remained there. So that first draft that she had put up was exactly this. So I waited for all other people who were on, and finally I said that, as much as the contribution of the United States is outstanding, there are other countries who have representation, and there may be other countries later on that might also have some representation. So how can you, talking to you, of course I support everything that the US does, but on the document, I have a problem. And after much seminars, webinars, all these things that happened, it became heritage sites. In the Artemis Accord, it doesn't talk only of the US.
Good afternoon, all panelists. As Mr. Malhotra in the very beginning said, race for seats, the seats were less occupied. I take it race for space. Now the seats are also fully occupied, almost very few minuscule left. And the race for space is also having very minuscule operational things left. Rest we are all fighting. Ma'am, small views from your rich experience. The space law legislation, the space draft space law, upcoming queries, questions, whatever we have discussed and seen from the experts like you. Can we foresee a specialized space courts, judicial platforms, because all the issues with respect to spectrum, the orbital things, and related aspects are now converging to the judicial interpretations. As we grow further, the things are going leaps and bounds. My vision for next 2030 is, rather 2030 would be a very big thing to say. Next year, once we attend India Space Congress 2023, we would be discussing many advanced things in terms of legislation also. So what are your views on having specialized courts on this specialized subject and field?
Thank you for that question. Now the point is this, that everything that happens in space starts and ends here on the Earth. When you're talking of commercial space, you're talking of private companies. And when those private companies seek to undertake activities in orbit, in outer space, they will get regulated by India's space activities law as and when that comes about. Now, what is the contemplation of liability in the international space, the Outer Space Treaty? Now look, India is a sovereign country. It is a ratifying state of the Outer Space Treaty. That means that the obligations that India has taken on arising out of the international treaty, India is in good faith required to implement them on ground. At the relevant point in time of discussion, the USSR was completely not in favor of private sector because they were a command economy. The USSR already had the Communication Satellite Corporation at the relevant time, and which was being regulated under FCC, federal laws. So they were very keen on their private sector entering, which is why you got this compromise in Article 6. Where the compromise was that fine, if your private sector is going to operate, it is your job as the state to make sure that they are in conformity with the obligations that you must fulfill, and that it will be required to be authorized under continuing supervision. That means of the state. So now a separate identity to a commercial entity has not been given by in the Outer Space Treaty. The state is responsible. How will it implement that? Typically what happens is that the license condition, license to operate, to launch, to operate, maybe now to even re-enter, because if it's an uncontrolled re-entry, it can implode around 120 kilometers up. And then you get debris. India's had 2 incidents just now. So therefore, the point is that it is the license conditions which will tell me that you can do this, you cannot do that. Those are India's obligations, and it is India's job to work out what should be in that license. As yet, it has never been granted to a private company. I suppose those are difficulties internal to the department, which they now must be trying to figure out. It's all very technical. As far as space courts are concerned, it depends on what the Outer Space Treaty says in context to liability. And what it does say in Article 4 is there is fault-based liability in outer space. Now, lawyers here will understand fault-based. Firstly, you got to prove to me that it was an Indian satellite or a piece of debris of an Indian satellite or launch vehicle that has blasted you out of, or bumped you out of the orbit you were in. So that is first and foremost. There is a time period given within which this should be filed. The second aspect is absolute liability. Again, lawyers will understand absolute. So this is in case damage is caused by the space object of a state to an aircraft in flight or on the earth. Like our debris that fell just now, we are told, we read from the newspaper that there was no damage or loss of life that has been caused to anyone. If an aircraft should be hit, splits into 2, let's think of an international flight. It's got 35 nationalities on board that flight. then your international air law treaties will come into play, private international air law. India has harmonized all those liability conventions in the Carriage by Air Act. It is a very complex system. And today, when we were, I mean, there was one of the air marshals was making a presentation on this new area. You know, he was talking about balloons and so on, that, you know, military aircrafts are traveling around 21, 22 kilometers, and then up to 100, you've still got sovereign airspace. What he did not say, of course, to this audience is what is going to happen if somebody else's balloon or aerospace vehicle fetches up over here? What are you going to do about it? Is it under surveillance? So my point is that there is now a convergence of air and space. We are talking of aerospace vehicles. You have seen what Richard Branson has done. You've seen Jeff Bezos. The first to do it in 2004 was Burt Ratton. So these are extremely technical, complex, military, and then commercial domains. To have a space court, I really don't know whether there is any need for it. Typically, what happens is that as between ratifying states, India and the counterparty have the option to dialogue with each other if they have caused, one asset has caused damage, or to go through the Secretary General United Nations. But I am a private company, I'm not the state. And nobody in Ministry of External Affairs is going to listen to me. They'll say that, look, we have no idea about all this. That is the importance of that space law that Ashok was talking about. What are the provisions that India will provide to her citizens to operate in space? Can I go to my own courts under law of torts? Then the courts will need to be sensitized to it. Can I seek international arbitration? I should be allowed under my law. Can I go to the International Permanent Court of Arbitration, optional routes for space dispute resolution? I should be allowed to do that, and or any other mechanism that is available to me. Because if you make it tight, then there may be other options available which I will not be able to do, because now the court will say that, you know, how show me the law. Indian law is going to say, show me the law, and I'll tell you whether you can do it or not. That is the way domestic law is interpreted. So space courts, I don't know, but 100% sensitization of our judiciary is of extreme value and importance. And I don't mean just at the top, I mean right down. If a piece of debris falls on some chap's house, splits the house in two, kills 3 people, makes a big hole, and just think about it, there's a spout of oil coming out. How will law treat it, our domestic laws? Where should he go? Will the DM immediately come to his rescue? Has the DM been sensitized? Will the local court over there take cognizance of this? Is there a special mechanism that if there's a piece of debris and they understand कि ये debris नाम की चीज़ क्या होती है, should immediately go to this special, I mean, DM is, let's say, specially empowered to do that, district magistrate? There's many dots that have to be connected. Many, many dots.
Thank you, ma'am, for that. I think, Ashok, you wanted to add a little bit, just, and then we'll have just one last question in closing.
So I'll just be very quick. So the Dubai International Finance Center Court has actually set up a space court. But I think the problem is the jurisdiction under international law is almost completely unclear. So I think on paper it sounds very exciting, and there have been some initiatives made to set up space courts, but honestly, whether or not they can exercise jurisdiction, whether there'll be any binding effect to their decisions, as Ranjana ma'am rightly said, it's a big question mark.
My question is for Ashok. You said that legislation is preferable to executive. So now with the space policy probably being issued fairly soon, we are following it very closely. I'm with Intelsat. And some rules and guidelines may be issued right away. Some may be issued after legislation is adopted. Should we be concerned about any rules or guidelines or regulations that are issued pursuant to the executive policy rather than the legislation?
So should you be concerned? I wouldn't say concerned, but you should certainly be interested. I think the point that we need to remember is law is ultimately a communication as to what the state intends to do with a particular subject, right? Now, if the messaging is stable and it is not something that can be changed at the whim of a hat, then you know that the communication of the state is something that can be relied upon in the short term and in the long term. But what happens with executive orders and guidelines and rules, especially when they're not based on a parent law which defines the policy framework, is you don't know at what point of time the position may change, and you don't know what the change will be like. And what this does is, and under the doctrine of legitimate expectation, ultimately the state does have the power to change policy narratives if it's in the interest of public policy. So there is no long-term stability with executive guidelines. It might actually happen in practice, but on paper, they remain volatile and they can change depending upon the government at the time.
Let me just add a word to that. Well, sir, just to add to what Ashok said, in court there is a hierarchy of authority, the authority of documents that you are giving. So first it will be the substantive statute, then it will be the rules, then it will be, and it goes down. Now, office orders, executive orders, guidelines are at the bottom of the line as far as authority is concerned. So that is what the problem is. It is true that we have been operating in this particular domain most definitely in context to authorities and guidelines, because it is the only gateway through which you can do anything. But now when you contemplate private players, you have to have a substantive law, you have to have the rules, because without rules you cannot implement. And those are the subordinate legislation, so you can keep adding annexes to it to, you know, as and how you go along.
Thank you. I know we've exceeded time, so thanks a lot to the organizers for allowing us to do that. And thank you for the audience to be staying along with us to hear our thoughts on this.
Thank you very much indeed. And ladies and gentlemen, I hate to stop such an interesting conversation that was going on.